All rise.
The Kosovo Specialist Chambers is now in session.
Be seated, please. Madam Court Officer, you may call the case.
Good morning, Your Honors. This is case CBC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Today we will conclude the testimony of witness 04408. I note that the accused are all in court except with the exception of Mr. Krasniqi, who's appearing via video link with permission. Madam Court Officer, please bring the witness in.
Mr. President, before you do, may I simply note that there's a pending request for leave to add documents to the presentation queue. I wouldn't normally postpone the arrival of the witness for that purpose, but there is one objection to that, and I wanted to note it.
What's the objection?
Well, first of all, I wanted to note the timing. These documents came in about 9 o'clock last night after a full weekend. I was here twice for the purpose of reviewing such documents. They didn't arrive until late. Notwithstanding that, we don't object to any but one. That is DHT01486-DHT01488, which is a summary of a witness who's already testified and has, I think, no genuine evidential value can be obtained from putting a summary to the witness. In addition, I note there are practical limitations also because it's not even in legal workflow.
Yes, it is Mr. Mustafa's summary.
A summary that was published by the SBO and filed by the SBO.
Yes.
And we had a series of questions as to whether or not certain things were consistent with understanding of what Mr. Damachi's role was, et cetera. We had a litany of those cases from the bench. This is consistent with that. This is what the SBO has said about Mr. Remy's comments concerning Mr. Damachi, and our simple presentation here is consistent with what happened with the judge's questions. Is this consistent with your understanding with him as a figurehead or your understanding of him as his role?
We will allow that document to come in. The only other question I had is about the Rambouillet document. I'm not sure what the relevance of that is. No one up here mentioned the Rambouillet conference at all.
Which document are you talking about? Which document
now
are
you're
you
going to make me
referring
find
to?
it.
That's fine. If I can go into private session while we talk about this, because I think it's something that, if I think it's the document that we're referring to, it's a document that Mr. Teager and I discussed, and if it was going to be discussed, it should be in private session.
DAT 01485. Is that what you're talking about?
I do believe that that is the intercept. Can we go into private session here, Judge, so I can speak freely? Is that DHT 01485, Judge?
1485,
If
correct.
we can just go into, if we can go into private session, I can address this, because I think that counsel rightfully asked us if we were going to talk about this document to do it in private session.
And that's all right. We're not going to talk about it now, but there's no objection by SBO. Am I correct about that?
There was no objection on the basis of the timing. I had understood, and by the way, in connection with the discussion of the previous document, there's no objection to documents that go to the issue raised in connection with Mr. Thaçi. I had understood this document, based on my very, very brief reading this morning, to be part of that. I'm looking at it more carefully now. Obviously, I leave it to the court, but as I say, there was no objection on the basis of timing, and there's no objection if it genuinely relates to the issue of Mr. Thaçi.
We'll just go ahead and try to get started. It seems like we will probably end up seeing most of these documents anyway, so that's all for now. If it gets to the point that it's beyond the scope of the judge's questions, I'll bring it up, or somebody else will.
Since we're discussing new material, I haven't heard any objection, but we have added to our queue, as a result of some of the questions, the United Nations Security Council Resolution 1244.
Yeah, there was no objection raised to that. So, for now, we'll go on. You may bring the witness in. Good morning, Mr. Abraham.
Good morning, Your Honors. Good morning.
Today, we're going to conclude your testimony with your cross-examination, or actually with additional questions from the defense based upon questions asked of you by the judges. I remind you to please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to explain or to repeat the question, and they will try to clarify or repeat as need be. Also, please remember to try to indicate the basis of your knowledge of the facts and circumstances upon which you will be questioned. I remind you, you're still under the obligation to tell the truth as stated by you in your solemn declaration. Also, remember to speak into the microphone and to speak slowly for purposes of translation. If you feel the need to take breaks, please make an indication and accommodation will be made. First of all, I know that Mr. Emerson and Mr. Kehoe intend to ask some questions. Mr. Roberts, do you have any questions as follow-up from the judges?
No, Your Honor.
All right, and Mr. Ellis, do you?
I'm not intending to, Your Honor, no.
Okay, and I understand something could arise, and we'll take that into consideration at the time. We will now continue with the testimony of witness 04408. The panel allows the Thaçi defense and the Vesely defense to examine the witnesses to address issues raised with the witnesses during questioning by the panel. In the light of the scope and duration of such questioning, the panel considers that 1 hour per defense team will be sufficient to recross or to re-examine the witnesses. So that will be the restriction, 1 hour each, and I'm sure that's adequate for you. All right. You may proceed. You have 1 hour. I'll try to remind you when you get about 5 minutes still.
Yes, Your Honor, thank you. Good morning, Mr. Abrahams. As His Honor just described, we're going to be talking about some of the questions asked by the judges. So if there's a bit of a skipping around of particular issues, bear with me, because we're not going to have a full panoply of questions, just on issues that were raised by the judges and our questions that emanate from those, okay?
Thank you.
Okay. So let me start, if I could, and this is on Judge Bartha's question. Judge Bartha asked you, and counsel, this is on page 7570, lines 13 to 20. Judge Bartha asked you whether Mr. Thaçi or Mr. Limai, and we're talking about the 10 November meeting, whether Mr. Thaçi or Mr. Limai mentioned that one of the detainees, one of the 2 Serbian journalists, was suspected of being involved in criminal activities in the Serb Republic of Krajina and/or in Bosnia in 1991 and 1992? And your answer was no, that did not come up. Do you recall that, sir?
Yes, I do.
If we can, let's take a look if we can put up Exhibit 300 on the screen. That's P300. My apologies. Now, you've seen this document before. It's Exhibit P300, and it purports to be statement number 3, allegedly from the Military Police Directorate of the Kosovo Liberation Army. And I'll just read the pertinent part starting at the top. On Sunday, 18 October of this year, at around 1500 hours, the Kosovo Liberation Army Military Police Patrol met a Yugo, Florida vehicle with registration plates from Belgrade near Margura village without press signs and a driver and a passenger, Vladimir Dobribic and Nihosha Radacevic. After the sign was given for them to stop, they stopped after a delay, thus allowing them to hide their identities. This also led to doubts about their identity, that is, not believing they are journalists and that the purpose of their visit is espionage. They were stopped and was sentenced to pretrial detention for the purposes of investigating their real identity and the purpose of their travel. Hey, would you agree with me, Mr. Abrahams, that this statement in P300 suggests that the two so-called journalists were detained because they had not identified themselves as press and were believed to be hiding their identities?
Well, I agree with you that based on this statement, that is the claim made by the Military Police Directorate.
And it also suggests, does it not, that they were suspected of engaging in espionage?
That is the allegation made by the Police Directorate, yes.
Now, just putting my case to you, the ICTY investigators concluded that Mr. Dobričić was involved in the commission of war crimes in Croatia in 1991 and that he had done so while using Tanjud press credentials in Croatia. My question for you is, if Human Rights Watch knew this information in October and November of 1998, you would have had doubts as to whether Mr. Dobričić was actually engaged in journalistic activity at the time he was stopped by the KLA. Isn't that right?
By this information, to what are you referring precisely?
Well, based on this information. Based on this information, you would have had doubts as to whether Mr. Dobričić was actually engaged in journalistic activity when he was stopped by the KLA. Isn't that right?
It would have formed part of our understanding of the entire case. Whether we believe these allegations or not this is the statement of the Police Directorate. So,
well, let's just change the dial a little bit and say, had you known in October of 1998 that Mr. Dobričić had been involved in war crimes in Croatia using Tanjud credentials, you would have found it much more likely, would you not, that he was engaged in the conflict in Kosovo as a participant. Isn't that right?
So there are two elements to that. The first is this knowledge about his purported crimes elsewhere would feed into our analysis. Yes, it would. And also our critique of this process was focused on the due process elements of the proceedings, or as they may have been, proceedings or not proceedings. And if there had been evidence of this person or both of them committing wrongdoings in Kosovo or elsewhere, then that could have and should have come out in the trial that purportedly took place.
But it likewise would have made it much more likely that when he is there, Mr. Dobričić in Kosovo with tenured credentials after he had been involved in war crimes using tenured credentials, that it would be more likely that he was involved in the conflict in Kosovo, isn't it?
But that should have come out in the trial. That may have or may not have happened.
Now, sir, Judge Bartha asked you some questions about the meeting that you had with Mr. Limai and Mr. Thaçi, and I'm referring to page 7569, lines 18 to 25, where you noted that Mr. Thaçi was speaking with most authority. Do you recall that?
Yes, I do.
Okay. And the fact of the matter was that Mr. Thaçi had introduced himself as a political directorate spokesperson, did he not?
My recollection and my testimony is that he introduced himself as the head of the political directorate.
And you understood the political directorate as an entity that was interfacing with internationals, right?
As part of their obligations or responsibilities, and I did not know the full extent of their responsibilities.
But he wasn't the person who was the military person in the room, right? He was in the political side, right?
That is how he presented himself, correct.
And he wasn't the legal side. You testified that was Limai, right?
That is correct.
So he is just there talking as a political person, as far as you knew, right?
Based on his presentation of the position he held, that is how I took it to be at the time, yes.
And the information that he may or may not have, let's put up Exhibit 378. If I may, before we do that, let's put up 375. Now, 375 is the Human Rights Watch press release that you folks came out with. If I could just take a quick look at it. And I believe it. Now, this is a Human Rights Watch press release of the 18th. If we just scroll down a little bit, get the right paragraph. If I may, it should be the third paragraph. It says, according to the information that you have, that these individuals went missing on October 18th. Do you see that?
Yes, I do.
Okay. Now, let us go back to Exhibit 378, and we'll talk a little bit about this, but later on, but I just want to talk about it preliminarily. Now, this is an article that came out on 1 November 98, some 9 days before you sat down with Mr. Thaçi and with Mr. Limai, and it's talking about the military court. And it notes that the trial was conducted on the 30th of September, 1998. You see that?
Yes,
that's fine. The military. I'll just read it for you.
I do see
the
it.
military court of the Justice Directorate of the KLA headquarters, based on the request of the military prosecution, and in conformity with its working norms, and the trial conducted on 30 September against Mr. Radisevich and Mr. Dobricic. Mm-hmm. So they're noting that the trial took place on the 30th of September, 1998. Now, you know as a fact, based on, well, as a fact, from your own press release, P375, that these two individuals didn't even go missing until the 18th of October, right?
Correct.
Okay, so this particular press release, for what it's worth, has complete information about one of the most important elements of this, which is when these two individuals were detained. Is that right?
It mentions the trial, yes.
Well, the trial, but you obviously know, Mr. Abrahams, that the trial couldn't take place on the 30th of September if these two individuals, according to your own press release, didn't go missing till sometime after 18th of October.
That assumes that this is correct. I would have to look more closely at it. I don't know for sure.
Well, I mean, let's look back at your own press release says that you received information from Tanyud that these two individuals went missing on October 18th, right?
I would have to look again. I'm sorry.
Okay, let's go back to, we'll do that. Anytime you need to do that, just let me know. P375, let's go back to that. This is your press release from October 24th. And I'm reading that paragraph beginning with Nibahosa Radosevich talking about these individuals went missing on October 18th.
Okay. Yes, no, the date is correct. What confused me was you said that according to Tanyuk, they went missing on October 18th, and I didn't recall the source of this information being included here. That's what threw me.
I'm sorry, I didn't mean to interrupt you, but you agree with me that Tanyud is the one that they didn't go, they went missing on October 18th.
Well, no, I'm just, I think this is a minor point, but you had said according to Tanyuk, and that's what threw me off. But the date is October 18th,
Okay.
correct.
So going back to 378, you have a trial that is conducted according to this article in P378 of some 19 days before that, and assumingly the trial probably didn't take place, if any, on the day that they were detained, right?
Yes, assuming this information is correct.
Well, with regard to this information, the information is totally wrong, isn't it?
Which information are
The
you
information,
referring to?
the most important information to you as to when these individuals were detained.
Well, I don't know that, because I don't know if this ARTA text is accurate.
Well, I mean, let's continue on. This is also the document that includes the military court of justice conducting this trial, while at the same time, Mr. Thaçi is telling you about civil structures and establishing civil structures, and that it takes a while to establish those civil structures, right?
Both of our interlocutors talked about the challenges of building structures, civil and military, in the midst of an armed conflict.
The individual that talked about the establishment of the civil structures, he testified, and I can pull the transcript out, was Thaçi, wasn't it?
I would have to look back, but he certainly, you don't have to pull it up. I know that time is an issue, but he definitely spoke about the challenges of building civilian infrastructure and mechanisms, yes.
Okay, so we have a situation with a trial that allegedly took place when these two individuals hadn't been even detained yet by a military court, according to this press release, or according to this communique that was military, and Thaçi is talking to you about civil structures and it taking a while to get civil structures established. Was it clear to you before, during, and after that nobody knew what was going on here?
No, it was not clear to me. I mean, that's a double negative. Was it clear to me? I was obtaining and publishing the material that was provided to us. I cannot say that this ARTA document or this date is accurate. I don't know. I can't testify that it was.
Well, you pay attention to these communiques, don't you?
They are part of our work, yes.
And so you paid attention to this communique either before the meeting or after the meeting, didn't you?
I believe I testified last week that I don't recall whether I had seen this prior to our meeting.
Okay, but we will get to that. But given this information and how wrong this information is, and given Mr. Thaçi's talking about civilian structures and this article talking about military structures, you will agree with me that what Mr. Thaçi was doing as this political representative was trying to put the best foot forward for the KLA to the international community, wasn't he?
He was certainly trying to put his best foot forward to the international community because legitimacy and international legitimacy for their movement and their struggle was extremely important.
And the fact is, as you sit here, he didn't even know which court conducted this case, did he?
I can't say that with certainty one way or the other. I can only tell you what I was told at that meeting.
Well, let's shift gears and we'll stay with Judge Bartha's questions to you, and we'll move to the meeting that you conducted. By the way, before we get to that meeting, and in that meeting, you noted for Judge Bartha, I'm talking about the August meeting, that you didn't have follow-up with Mr. Thaçi after you gave him your report. Is that right?
That's, excuse me, that is correct.
Okay, and did you bring up with Mr. Thaçi, let's go put Exhibit 376 on the screen. It says P376. And we'll get back to the follow-up in a second, but just preliminarily, we would want to talk about this. Do you recall this letter that you sent on December 2nd, 1998?
Yes, I do.
Now, during your meeting with Mr. Thaçi in April of 1998, did you ask him if he ever got this letter?
April 98 is which meeting?
August of 1999, my apologies. When you had your meeting with him in August of 1999 to give him a copy of the report, did you ask him whether or not he received this letter of 2 December 1998?
I do not recall if I asked that question.
Well, that would have been an important issue for you to know, is it not, whether or not he had in fact received this letter?
I do recall that we acknowledged our meeting in November because it was a natural human interaction. Good to see you again in very different circumstances, but I do not recall whether we raised this letter or not.
Well, this is dated the 2nd of December, 1998. Did you know that Thaçi had left Kosovo by mid-November and didn't return until March of 1999?
Sorry, which dates were you?
Were you aware that Mr. Thaçi left Kosovo in mid-November, mid to late November of 1998, and didn't return to Kosovo until March of 1999? Were you aware of that?
I'm not familiar with his movements during that time.
Okay, so when you wrote this letter, you didn't do any follow-up to see if, in fact, Mr. Thaçi had received this, did you?
We sent this letter and did not receive a reply, but and that was the communication.
My question is very simple. You did not do any follow-up after you sent this letter to ensure that Mr. Thaçi received this letter, did you?
Not
yes
as
or
far,
no?
Not as far as I know.
Now, going back, if we may, to the questions of Judge Bartha in your August 99 meeting, and pardon me if I get some of these dates.
There's a lot of dates.
There are a lot of dates. And at page, this is page 7571, line 4 to 8, and then line 12 to 15. Judge Bartha asked you whether your meeting with Mr. Thaçi in August of 99 was conducted in Albanian or in English, and you said that your recollection was that the meeting was conducted primarily in Albanian. Do you remember that?
I do, yes.
And you also told Judge Bartha that you and Mr. Thaçi were the only individuals at this meeting. Do you recall that?
Yes, I do.
Now, last Tuesday, page 7298, line 2 of the transcript, you testified that you speak Albanian, quote, to a degree, not fluently, end quote. Do you recall saying that?
Yes, I do.
So at this meeting that you had, if the meeting was predominantly in Albanian and you do not speak Albanian fluently, then you can't be certain that there were no misunderstandings during that meeting between you. Isn't that right?
So, I mean, with regards to my Albanian language skills, I have given numerous interviews on Albanian language television, so my abilities can be judged. That's in the public domain. As for the meeting, and to your question, in my view and in my opinion, I understood the essence of his responses. I understood the core meaning of his responses, and he likewise of mine.
Mr. Abrahams, you said that, quote, you speak to a degree, not fluently, end quote. Wasn't that your testimony?
Yes.
Okay, so that by your own admission, you are not fluent in Albanian, right?
Absolutely correct.
Okay,
yes.
and Mr. Thaçi's, to your knowledge, his knowledge and ability to speak English is extremely rudimentary at best, right?
Now or at the time?
At the time, August of '99.
I can only say in his English communication at the time, that was my impression.
Okay,
yes.
so given the fact that you are not fluent, he doesn't speak English, and you, again, can't be certain that there were not misunderstandings during this meeting.
Objection, asked and answered.
Sustained.
Let's move on to the communiques themselves, and I think that you mentioned, let's turn to page 7576, lines 23 to 25. And I think that was in Thursday's transcript, by the way. You told Judge Matreau that you placed a, quote, high value on these communiques because they are produced by the official structures in this case, the armed group. Do you recall saying that?
Yes, I do.
Now, if we can put Exhibit 378 back on the screen. I told you we would get back to this in a different subject, and here we are. Now, again, this is the statement issued by the KLA on November the 1st, 10 days before, or at least 9 days, 10 days before your meeting with Mr. Limai and Mr. Thaçi announcing the so-called journalist had been convicted and sentenced and transferred to prison number 7, and that this was published by ARTA. You see that up in the right-hand corner, that it's published by ARTA?
Yes, I do.
Now, you also said this morning, and you said that last week at page 733, lines 1 to 2, you don't believe that you saw this prior to the publication of the Human Rights Report in December of '98. Do you recall saying that?
I don't, but I take your word for that.
So you did not see this communication by the KLA prior to your meeting with Thaçi and Limai, even though the subject of the communication was the same subject, among others, for which you had sought a meeting with the KLA, namely regarding the detained journalist. Is that right?
Well, the purpose of our meeting was multifaceted, and this was one element of it. And we focused on the case of Mr. Raglicevic and Dobricic because it had garnered attention, and it was a case of concern into which we could highlight issues related to detention and potential abuse. But it was not the only subject we covered, and it wasn't our intention to go there with that sole purpose. But in addition, to present the full panoply of our work on Serbian and Yugoslav abuses, we also asked at that time, if you have information about alleged war crimes by Serbian and Yugoslav forces, we are open to receiving that evidence or information, and also allegations of their conduct writ large with regards to international humanitarian law. So it wasn't only the journalists.
So, but you testified here for several days, right? In response to counsel's questions, in response to defense questions, in response to the bench's questions about this meeting on the 10th of November, 1998, concerning these two alleged journalists, right?
That's correct.
And you just told us that this matter had received a lot of attention at the time, is that right?
That is correct.
And it had received a lot of concern at the time?
Correct.
And that was one of the reasons why you brought that subject up in your meeting that you sought with the KLA, right?
That is correct.
Okay, yes, but given the fact that you had not received or do not recall seeing this communique prior to this meeting or even prior to the publication of the Human Rights Watch report, at least this communication was not important to you, isn't that right?
No, it just means that I can't testify that I had seen it at the time.
You didn't see it at the time, and you didn't see it when you said that you made a publication, when, in the end of December, and then another publication again in August of '99? Is that right?
I would have to look back again, but then I believe we referenced this at some point in one of our publications. I'm sorry if I'm conflating the two now, but
as you sit here, do you have any idea where you referenced this communique?
Well, we referenced prison number 7, so maybe that's what I'm thinking of, and I can't recall exactly where that emerged. It was another.
So you got the information about prison number 7 at some point from this communique?
That I don't recall.
Now let us change subjects a bit about Adam Damachi, and you were asked several questions by Judge Matro about Adam Damachi. Do you recall that?
Yes, I do.
And do you recall that Judge Matro asked you whether you were familiar with the release of a Serbian policeman named Goran Zbilic from KLA detention, and you said you weren't familiar? And do you recall that answer? And by the way, just for reference purposes, I'm talking about page 7579, lines 2 to 6. Do you recall that?
Just so I'm answering you accurately, that I was not familiar.
You were not familiar?
Correct, I was not familiar.
Yeah, I didn't, that wasn't, maybe my...
I just didn't hear
That's
clearly.
fine. And maybe my negatives were transposed, but you and I are on the same page. That you had not known about that. I believe you responded to Judge Matro. That's right.
That is correct, yes.
And then Judge Matro proceeded to read from you a transcript, which was a press conference where, in talking about the Zbilic matter, that, quote, however, I am not entitled, where Damachi at this press conference said, however, I'm not entitled to interfere in these matters. I can only interfere as a human, a humanitarian, and come up with good proposal. You know very well that's not up to me. And bear with me a moment. And then Judge Matro asked you if that is consistent with what Damachi told you when you met with him, that he did not have decision-making power over the fate of these individuals. And your response, and I quote, this is at page 7579, line 21 to 7580, line 5. Counsel has stood.
Okay, yeah. Sorry.
Okay. That your response was, this is consistent. I left the meeting with Mr. Damachi in which this was discussed with the distinct impression that he did not have the authority to release people.
I just wanted to note, although I'm obviously trying to follow this quickly, that I think the preface contains an inaccuracy, and that is it suggests that this comment was about the detention and release of Mr. Zbilic, and my recollection, as I'm trying to find it quickly now, is that it was about the detention of Mr. Dobricic and Mr. Radojevic.
Can we straighten?
It's about that. This particular reference back and forth is about Zbilic. And he does say the same thing, similar things with regard to the two journalists.
Could we just wait a moment? Let's see if they can find their reference.
It's at page 3 of 061427-11-TR-ET revised under time step 01053 and 01108.
I will say, Judge, that there is some mixing here, but for the purposes of the next question.
No, he just given you this, where it is.
Oh, okay. And I can tell you, Judge, that for the purposes of my questions in this regard, it really doesn't make a difference. It started with Zbilic, but he said he didn't know, but then it carries on talking, counsel is 100% right. It goes on talking about the two. Actually, Judge, if you look at Judge Mitro's transcript, and unfortunately this is the temporary transcript, Judge Mitro says, line 4, can we then go to page 3 of that record, and I'll ask you to look under timestamp 1053. There's a question by a journalist which says, following Goran Zbilic's release, families and relatives of Nebojša Radičević and Kiko Dobricic are voicing doubts that the two are alive despite your statements to the contrary. So in fact, he's talking about all of them.
Anything further from the prosecutor?
No, Your Honor.
All right, Go ahead. Go ahead with your question.
Thanks,
You may have to start it.
Let's go back here. So we're then talking about that Judge Mitro read the comments by Damaci, and when he said, however, I am not entitled to interfere in these matters. I can only interfere as a humanitarian, and come up with good proposals. You know very well that it's not up to me. Then, Judge Mitro asked you if that is consistent with what Damaci told you when you met him, and that he did not have the decision-making power over these individuals. Now, your response is at page 7579, line 21 to 7580, line 5. That is consistent. I left a meeting with Mr. Damaci in which this was discussed with the distinct impression that he did not have the authority to release these people. You recall your testimony?
Yes.
Well, let me just show you something concerning the authority of Mr. Damaci in the case of Mr. Zbilic, and ask you the same question that Judge Mitro asked you, namely, whether it is consistent with what Mr. Damaci told you when you met with him. And I would like to put up DHT 01486, and I'm going to focus on DHT 01488. Now, before we put that on the screen, when this was filed, Your Honors, it was filed confidentially. I don't know if that confidentially still applies, because this relates to Mr. Mustafa's testimony, which has already happened. So in the spirit of caution, I just raised that. I have no objection to it being put on the screen. I leave it to my colleague across the well for his comments.
Any objection to broadcasting this particular document?
No, Mr. President.
All right, go ahead.
So let us turn to this document, and I am talking about paragraph 12. And it notes, this is a summary by the prosecution of the evidence of Zone Commander Mustafa, Rustam Mustafi, obviously talked about as Commander Remy, and this is what they had to say. Paragraph 12. The witness being Remy, will also testify about the detention of Zoran Zbilic, member of the Serbian Security Service, in November of 1998. in Lapashtice. The general staff was informed of his intention and then let the W4746 is Mr. Remy decide what to do with him. Adam Damachi then intervened for Zbilic's release after William Walker and Sean Burns from OSCE became interested in the case. Damachi's word carried a lot of weight at the time, and therefore Remy, Rustam Mustafa, decided to release the detainee. Now, in addition to this comment about where the prosecution notes that Damachi's word carried a lot of weight, including Remy's decision to release the detainee, Judge Matreau raised with you, let me read for you what Remy actually said and testified to in this courtroom. And this is a transcript from 13 July 2023, page 5614, lines 11 to 14.
Your Honor, before we move on, I'm sorry, counsel, but in the interest of accuracy, this is not a comment by the prosecution about how much weight Mr. Damachi's word carried or didn't carry. This is a summary of what Mr. Mustafa was expected to say, and there's a difference.
That's correct.
I stand correct.
Yes, yeah.
You're right, counsel. And to the extent I misspoke, I apologize. So, he testifies that Damachi's word carried a lot of weight, and let's see what he noted to the prosecution that it carried a lot of weight, and let's see what he actually testified to. Again, this is at page 5614, 13 July, lines 11 to 14. And we're talking about the release of Zbilic. Question, so can you please explain what involvement Adam Damachi had in the release? Adam Damachi was an authority for us, and we obeyed his words, and therefore we released the person. Now, is this consistent with what Mr. Damachi told you when you met him?
No.
Now, Judge Matreau also put to you a portion of the press conference where, this is the Damachi press conference with Rogova that Judge Matreau was talking about, where Damachi claimed he had appealed to the general staff for the release of Mr. Bilic. Do you remember that?
Yes, I do.
And let us turn to that, if you can see. Now, as you can see from the summary of the SPO evidence, it was Remy's decision to release Zbilic. You see that?
There's nothing on my screen.
Couldn't you put the document back up? Look at the last line. In that line, Remy, in this summary, it was Remy who decided to release the detainee, not the general staff. Do you see that?
I see this, yes.
Now, was that, again, consistent with your understanding of Damachi's role and in his position?
Yes.
So here is Damachi. He would tell a commander, a military commander of the LOP zone, one of the operative zones, and that commander, according to his testimony in this court, obeyed his words and released Zbilic, right?
So, I do not have insight into the relationship between Mr. Damachi and Mr. Mustafa. What I do note here is that, based on this text, that Mr. Mustafa held Mr. Damachi in high regard, that he received his request, and then himself decided to release the detainee. So in my view, this is consistent that Mr. Damachi had a moral authority, a reputation, and made interventions on which military members of the KLA decided.
Let us continue on this, sir, and we have a bit more to get through. And by the way, you also Judge Matreau also showed you a portion of the press conference where Damachi stated, "It's not up to me on matters of detention." Do you recall that?
Yes, I do.
Well, that was quite similar, was it not, to what Mr. Thaçi told you? When he told you that it would, and I'm talking about page 7523, that it would be improper to interfere with civilian judicial authorities. He basically said the same thing as Damachi, didn't he?
Mr. Thaçi said that they had to respect the independence of the judiciary. They could not interfere. And also that an early release before the sentence had been completed would undermine KLA authority.
Okay, so it would be, Thaçi's telling you that it would be improper for him to interfere in judicial proceedings, and that he, like Damachi, had no authority over detentions. Isn't that right?
He said that they would not intervene because of the two reasons that I just mentioned.
And because it would be improper for him to intervene, right?
Because they needed to respect the judicial processes. That was his statement.
Yes. That is akin to what Damachi told you, wasn't it?
Slightly different.
Well, basically the same idea, wasn't it?
In Damachi's case, I took it to mean that he lacked authority, not that he was unwilling to intervene.
Well, and then Thaçi, as a political representative, is telling you it's improper for him to intervene, right?
That was Mr. Thaçi's statement, correct.
Well, let's go on. You also noted in your response to the questions by Judge Matreau that you were asked whether Damachi was acting under the authorization of the general staff, and your answer was that this was consistent with what your understanding. Is that right? That was on page 7581, lines 4 to 15. Do you recall that?
I'm very sorry. I'm not trying to be difficult. I don't recall that.
Okay. So you don't recall telling that to Judge Matreau that Damachi, when Damachi said that he was acting under authorization of the KLA, that was consistent with your understanding of how Damachi was acting. Is that right?
I would suggest in this case in particular it would be useful to be more specific about the reference, which contains elements that may assist the witness in understanding.
It would assist the bench as well.
Yes. I'm just trying to move through this in the interest of time, Judge.
If it helps, Mr. Kehoe, it's page 7 of the transcript of the press conference, and it was at page 7581 of the transcript of last week.
And Judge Matreau, thank you, Judge Matreau. On page 7, in the translation, Damachi said, "No, I have authorization from the KLA General Staff." And you were asked the question by Judge Matreau that about this particular comment, and that you noted, the question is that consistent with your understanding that Damachi would be acting, at least in this particular context, under the authorization of the KLA General Staff? Or is that conflicting with your understanding? And you said, no, this is consistent.
Your Honor, that's precisely the nature of the objection. Counsel mentioned in this particular context, the context was not mentioned here, and you can find that on page 7581 at lines 9 through 10 of the transcript, and that's the basic issue.
Be that as it may, we are
Just a
talking.
second, we will find that reference in our analysis of these questions. So thank you for pointing them out to us.
In line 17, as Judge Matreau wrote, he quoted the document and said, "I have authorization from the KLA General Staff to form the Assembly, to form the government, to form the negotiating group." Do you recall that question?
Yes, I do.
Okay. And then when the judge asked you whether or not that was your understanding, that 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 Mr. Damachi was operating with the authorization of the general staff? And you said yes.
That's correct. I believe then and still believe now that Mr. Damachi's political representation with an office in Pristina would not have occurred without the authorization of the general staff, or at least of the KLA at the time, KLA writ large.
Tell us, Mr. Abrahams, which specific individuals in the KLA general staff was Damachi obtaining authorization from?
I do not know the answer to that
So
question.
when you're saying that he's operating, when Damachi's operating in upon the authorization of the KLA in response to questions by Judge Matro, you can't tell us the individuals that he was obtaining that authorization from. Is that right?
What I can tell you is that there is no way he would have been allowed to function in Pristina with that position, and it was never contradicted by anyone in the general staff or otherwise. But if you're asking me about the individuals who were involved in those conversations and decisions, I do not have information about that.
Let's just go to the next document, ERN 01167 at 68 in the Albanian, and in the English 061168 061168 at 061168. If we could put that on the screen. Now, Mr. Abrahams, you could take a quick look at this, but this is a draft agreement which the KLA and the FARC agreed to unify into one formation. And it is dated 2 November 1998. They agreed to unify into one formation. As I say, this draft agreement is 8 days before you met with Mr. Thaçi and Mr. Lima. If you look to the bottom of the page, it says the agreement will only enter into force if it is approved at a subsequent meeting in which Adam Damachi will be one of the participants. So from this document, Adam Damachi was to be one of the people deciding whether to affirm an agreement to unify military formations. Now, is that consistent with your understanding of Mr. Damachi's role?
Yes. I mean, I never have said that Mr. Damachi was irrelevant, unimportant, or not influential. But I do still believe he was largely in a role as public and representative with internationals like myself, diplomats, and also the Albanian public who held him in high regard. And that doesn't mean he wasn't part of conversations. And what I would argue in this case is an internal Albanian negotiation in which he could and apparently did, it's the first time I'm seeing this document, play a role.
And he played a role by this document saying that it is not coming into, will not coming into effect until he endorses and approves it, right?
That's correct.
And in endorsing and approving this joining of two military forces, that is not the role of a figurehead, is it?
I don't think it's inconsistent with my characterization of his role.
Okay. Didn't you tell Judge Matro that you thought that he was a figurehead? Didn't you say that?
I believe those were his words, and my response has been, and my view consistently has been, that he was an important figure in Kosovo-Albanian society, but he did not have strong influence and decision-making abilities or authority over military matters. In my view, this conversation was very much an internal Albanian political discussion, clearly with security relevance. I'm not suggesting it had no security relevance whatsoever, and Mr. Thaçi apparently played a role.
In the interest of time, let me move ahead and show you another document, which is DHT 0148 at 485. And we're talking about DHT 01485. And Your Honor, this is a document in consultation with counsel that has to be discussed in closed session. Private session, Judge.
Private session.
Private session, my
Please take
apologies.
us into private session, Madam Court Officer.
Your Honor's public session.
So, in the context of the going to his office and giving this to him, you have said in that report concerning the actions of UNPRA 4 and K4, and I say, and I point you to 379, page 22513, that the overall response of the international community to attacks on minorities in Kosovo has been belated and inadequate. You went on to say, as of July 22nd, few of the 1,800 regular international civilian police and 1,000 special international civilian police authorized by the UN have been deployed, although a number of officers from the International Police Task Force in Bosnia have been temporarily seconded. Despite these efforts, the finding of this report makes clear that the current ad hoc arrangements for policing are woefully inadequate to meet Kosovo's public order requirements. That's your criticism of UNMIC. You then went on to the next page and noted that K4's overall record on preventing the abduction, detention, and murder of Serbs and Roma is poor, is also poor, right?
Very much correct, yes.
Okay, so during this period of time, when you're going to see Thaçi, you have a disastrous situation on your hands because UNMIC and K4 can't control what's going on, right?
NATO forces came in with firepower, prepared to face Serbian and Yugoslav forces, and they did not prepare or intervene adequately in civilian policing functions or military policing functions. And the UN as well had far too few police to manage this situation. It was one of our main critiques of the international organizations, a gross failure of a predictable problem.
And through June, July, and August, the person on the Kosovo side that's out there condemning violence is Hashim Thaçi, isn't he?
He made public statements condemning some of the singular or the most egregious attacks.
You mentioned
Yes.
Grachko being one of them.
That's correct.
Okay, and he was also up in Mitrovica to defuse the crisis in Mitrovica in late June of 1999 when the Serbs were on one side of the river and the Kosovo Albanians were on the other side of the river, and they were about to have a conflict, and it was Hashim Thaçi who went up there and diffused that crisis, didn't he?
I'm not familiar with that particular incident.
You're not familiar with that?
No.
You are familiar, are you not, that in addition to condemning violence on numerous occasions, that it was Thaçi who was out there consistently calling for a multi-ethnic society and for the Serbs not to leave, didn't he?
Mr. Thaçi made public statements to that effect, yes.
And he did that continuously throughout this period of time, both in the international and in the local Albanian media, which you noted before you were processing and reviewing, right?
He made public statements condemning violence, yes.
Okay. And but I'm saying he did it not only in an international setting, he did it in the local setting as well, didn't he?
I believe yes.
Okay.
Yes.
So you would agree with me that he was the only person, leader in Kosovo at the time, condemning violence, trying to prevent violence, and calling for a multi-ethnic society. He's the only one on the Kosovo-Albanian side out there publicly making these statements, isn't he?
Objection, that's a compound question. You should break it down to its elements.
In the interest of time, Judge, I'm trying to finish this.
Just answer the question if you can.
I can, Your Honor, and the answer is no. He made statements condemning some of these singular incidents, but there were other Kosovo Albanians who absolutely were discussing, were condemning revenge, were calling for respect for human rights, that the new Kosovo, from which they knew in the past, Albanians knew repression and violence, that they could build a new future without that. And there were definitely other Kosovo Albanians making that point.
Just one last question, Judge.
Very short one.
Very short one. And the person who was out there who was involved in the provisional government was in fact Hashim Thaçi, not Rugova, not Bukoshi. he was the one, in conjunction with others, that were making these statements to stop violence from a multi-ethnic society and separating people who are in conflict, right?
No, there were others out there.
I'm agreeing with you.
Oh,
I'm agreeing with that. It's Hashim Thaçi, in conjunction with a handful of others who were out there,
Mr.
who was saying this to stop violence, multi-ethnic society, and
Mr.
there should
Keogh,
be a
you're saying that
separation.
for the second time, and your time is up.
Mr. Abrams, thank you very much. Have a safe trip home.
thank you, sir.
Mr. Emerson, you have the floor.
I'm beginning to ask you some questions, and this is for the record, arising out of the questions and answers you gave to questions asked by Judge Metro, page 7576, line 23. It's been mentioned in passing by Mr. Kehoe. You were asked about the significance that you and Human Rights Watch attached to the accuracy of communiques and statements purportedly issued by the KLA, and your answer was, so we would place a high value on these communiques because they are produced by the official structures of, in this case, the armed group. So statements produced by the party to the conflict are, for us, considered important information, without any doubt. Now, I just want to probe with you what that means in terms of important information without any doubt, and in particular, the high value that is placed by Human Rights Watch on those statements, because they appear to emanate from official structures. And for the sake of an example, could we call up the document that's been looked at recently, that is P378, which is the communique about the two journalists, which appears to have been written by somebody who didn't know that their detention happened for the first time almost 3 weeks after the communique says they were in fact put on trial. So it's in that context.
Sorry, but that's a comment. If there's a question, you can ask it, but not to
certainly
embed it in commentary is not appropriate.
Well, I'm sorry.
Go ahead with the question, please.
Yes. So I want to ask you, you are a specialist for Human Rights Watch in humanitarian law, is that right? In the application of humanitarian law standards?
Investigations into violations or alleged violations of international humanitarian law.
So, as an expert in humanitarian law, are you familiar with military structures and practices generally?
Well, first of all, I'm not a lawyer, so I refer to our legal teams for the details and the specifics, and I investigate apparent or alleged violations.
But presumably you know of typical structural issues, at least with conventional armies.
Can you explain
Well,
what you
yeah,
mean by
I will
structural?
explain. Do you know, can you give for us a working definition of PSYOPs, or psychological operations as they're known?
I'm going to object. I think this is, at this moment, seems to be beyond the scope of the judge's
It
questions.
is beyond the scope of the judge's questions.
Well, with respect, it's not, because I'm asking about the rate that is applied to these communiques, which I'm saying to suggest to the witness are an example of psychological operations. Well, it's clear that the witness has testified in answer to Judge Metro that Human Rights Watch attach importance to authorized statements from what they perceive to be a party to the conflict.
And what does that have to do with PSYOPs?
Because PSYOPs is very specifically a procedure and a responsibility of which, for example, the United States has divisions, which is designed to produce information to create an impression that isn't true. That's what it is. And having now...
Let's establish whether this witness knows anything about that, because he's already said he doesn't really deal with issues like that, but you go ahead.
Well, he said he didn't deal with the law, but this is a question of, you know, surely, when you're taking into account, as you've said, the reliability of statements and communiques, that all military formations operate psychological operations, as they're called.
Yes, I am aware of that.
Well, let me put a working definition to you, and forgive the rudimentariness of the source, but it's the first paragraph of the Wikipedia definition of PSYOPs, and see if this is what you would understand PSYOPs to mean. PSYOPs are operations to convey selected information and indicators to audiences to influence their motives and objective reasoning, and ultimately the behavior of governments, organizations, groups, and large foreign powers. Does that sound familiar to you as a good working definition of PSYOPs?
Well, as an investigator, I try not to rely on Wikipedia, but in this case, I would agree with this definition.
Exactly. I try not to rely on it, but it seems like such a good definition. I mean, you know, for example, that within a conventional military like the United States military, there is a special operations command which encompasses the 4th and 8th PSYOPs divisions in the Army and the 193rd Special Operations Wing in the Air Force.
I'm not familiar with the precise units, but clearly PSYOPs are a part of at least the U.S. military.
There's that old expression, the first casualty of war is truth, but we're really talking about the old concept of war propaganda to create an impression.
Propaganda is a part of conflict.
And nowadays it's called PSYOPs, essentially.
I agree.
Yes. So when, for example, as we see it every day, you know, there are statements saying, for example, Ukraine is winning despite the fact that it hasn't made any progress in the last week or so, that you have to take with a pinch of salt, don't you?
I agree.
Because you have to factor that in. So when you say you place a high value on the communiques because they come from an official source, and they're therefore considered important information without any doubt, you're not saying, are you, that you treat them as accurate, just that it's important to your overall analysis to note that the statement has been made.
Thank you for that question. When I said it's important information, that is because it emanates from one or another party or an official source, be it NATO or anyone else involved, but that is distinctly different from accuracy.
Because it may be designed to manipulate the readership in order to gain an impression of the strength of your forces or the depth of your organization, which is misleading. Is that correct?
It may and may not be accurate.
Exactly. But that's the reason why it may be inaccurate, is because those who've issued it are trying to create an impression that they think is going to affect either the enemy or a third party in their tactical decision-making.
That is one of the reasons that it might be inaccurate.
And you've told us in the testimony you gave on Thursday that as you saw matters at the time, it was difficult to discern whether the units on the ground had a relationship or what any relationship was to a central command, as you saw it at the time. Correct?
That's correct.
And we went through the fact that it was, as you described it, strong, characterized by strong regionalism, dominated the organization. You talked about how the zones raised their own funds and bought their own weapons. You told us that the level of organization and central command was only really put right by about March 1999.
It was a process.
Exactly. can we call that P378 back onto the screen? We've already touched in this case on records showing that, for example, in the Ducagene zone, when it was being set up, they appointed a commander for chemical and biological warfare and a commander of an anti-tank division. But these were purely, as I'm sure you can testify, Pyrrhic names. They're empty names, correct?
I'm not familiar with those appointments. That's the first I've heard of it.
But we have the documentation.
I would say, were those to have been created, I never saw evidence of the existence
of any such
of either of those.
But they might, would you agree from your specialist expertise, they might in fact be names and titles given to people to create the impression that the KLA was better organised and better equipped than it really was.
That is possible, yes.
I mean, is that something you saw any evidence of?
In general, the KLA was trying to present itself as the legitimate defense for and force for the independence, fighting for the independence of Kosovo. There's no question about that. And so presenting themselves as a credible and serious fighting force was part of that interest and campaign.
Even when, as you told us last week, they were primarily a disorganised collection of armed villagers, often built around family structures without a clear chain of command. That was your testimony. And you would say, even in such circumstances, they would be trying to convey the impression of an organised armed force.
Correct.
Mr. Teager.
Sorry. Your Honor, it seems to me the repeated traversing of ground covered by the witness already in relation to matters that don't appear to directly concern the comment about communiques falls outside the scope of the questions.
Overruled. Go ahead.
Thank you. Thank you. So let us look at this document for a moment. Well, we know you've already dealt with Mr. Kehoe with the fact that it claims the trial happened on the 30th of September, and all of the other evidence and the indictment alleges that two people concerned had not in fact been detained at that time. Whatever the exact difference of time is, that's a clear, on the face of it, inaccuracy. But what I want to ask you about is the context of that. So, the military court of the Justice Directorate of KLA General Headquarters, based on the request of the military prosecution. Now, and in conformity with the trial, that certainly inaccurately recorded as to the date. Now, the military court, this is dated, I think it's a November date on it, is it? Yes, the very first of November. The military court of the Justice Directorate of the KLA, well, let's just start about the Justice Directorate of the KLA. Would it surprise you to learn that there was no such thing?
So, first of all, I feel obliged to point out the date, the 30th September. It's not on the face of it an inaccuracy. It's on the face a discrepancy.
Fine. I don't know what the difference is, but carry on.
Well,
I wasn't asking you about the date. I was asking you about
No, but you did mention
Sure.
the date, so I
don't understand the difference between a discrepancy and an inaccuracy. Do you want to explain?
Well, there are two different dates, and we need to understand why.
Is that an inaccuracy or a discrepancy?
That's a discrepancy.
I see.
You're claiming this is inaccurate, and I don't know that to be the case.
So they might have had the trial before they were arrested? Is that what you're suggesting?
Now, this is suggesting that they had the trial before or this is suggesting that the trial was conducted on September 30th. So I don't know that to be true.
One possibility is that whoever wrote this didn't have any accurate information. And that seems to be clear, didn't have
That's
accurate
possible.
information. That's not really the issue. It's part of the document that's been constructed referring to a Justice Directorate of the KLA General Headquarters on the 1st of November. Now,
Yes.
apart from your conversation with Mr. Limai, who also, for whatever reason, used some reference to himself being a legal or justice official.
I believe head of the legal directorate, I believe.
Right. But which I think you said is interchangeable with justice.
Judicial, I remembered, it's either head of the judicial department or head of the legal.
Either way, if, as independent evidence will prove, there was no such thing at that time, would that be consistent with what you consider falls within the definition of PSYOPs?
That they claim to have a judicial directorate, but in fact there was no judicial directorate.
And a military prosecution when none existed.
Well, first, I don't know if the judicial directorate existed
No,
or
I
not.
understand that. That's a matter of other evidence.
I will leave that to this process. And if they had claimed there was a judicial directorate and there turns out not to have been one, there are different possible explanations for that, of which PSYOPs might be one.
Exactly. It would be, within the terms of what we agreed was a working definition, conveying selected information, selective, in this case, misleading, if that hypothesis is correct, to create the impression that the KLA was stronger and more organised than really it was. That would be how it would fall within that type of activity.
Yes.
Yes. And we can call it fancy names like PSYOPs, but it's as old as war itself, isn't it?
I agree.
Yeah. I mean, you don't have to be the United States military to try to create the impression that you're better organised, stronger, more technically better armed, and that you present a more formidable opponent. Do you agree?
I agree.
And in the context of Kosovo in 1998, that might have two functions I'm going to suggest to you. One, to make the Serbs think they had a real enemy. Do you agree? A stronger enemy than they actually had.
I agree.
But more importantly, perhaps, or certainly as importantly, to make NATO countries like America and the UK think this is a sufficiently organised group for us to back and put our resources, our training and our military support behind. It's not just a rabble of, as you described it, a disorganised collection of armed villagers with no clear chain of command. It's not just that. It's actually something with a proper structure. So we actually can deal with these people. Is that right? Would serve that purpose as well.
Well, certainly getting the support from Western military powers was a primary goal.
A key KLA objective.
Without any doubt. And showing themselves to be reliable partners, also with respect to stability, security, and human rights and democratic values, would be important.
And you've already observed that in some respects they may, your opinion is that they made statements of adherence to humanitarian law that were not 100% reliable. Is that right?
That is my testimony in this court.
So it must follow, mustn't it, from what you said, that the statements about their organisation are equally unreliable, potentially?
I don't draw that conclusion.
Well, let me put it another way. As you've told us, when you're looking at communiques and documents, you have to adopt a high degree of caution because of the risk that they are in fact a manifestation of psychological operations, of PSYOPs. And you take that into account.
We receive information from all parties to the conflict, with this as that being the stated position that requires interrogation.
Exactly, and corroboration.
And corroboration.
Did you ever find any corroboration or come across any that in November 1998 there was a Justice Directorate of the KLA General Headquarters with an operational military court and a military prosecution other than your conversation with Mr. Thaçi and Mr. Lima? Did you find any independent corroboration?
So we encountered members of the military police.
That's not what I asked you, though.
Well, but it is part of the...
Let him finish his question first, please, or his answer.
Part of the military judicial mechanisms or apparati would include the military police. And I personally did encounter members of the military police who showed us identification as such, as being members of the military police.
Could I ask you to pause there? Did you look at that documentation?
You mean the...
You examined their documentation, the people claiming to be military police?
How do you mean examine?
You
What's
said they
your
presented
definition?
you official documentation. Did you look at it?
I did.
Who issued it?
I do not recall at this
So
time.
it doesn't really help us, does it?
I think it does because multiple people had this identification and presented themselves as such.
Issued by the same authority?
That I do not know. If I did not examine all of them, then...
I mean, it could just be something somebody produces to say, I'm in charge here, couldn't it? Within your context, as you described it.
I did not take it to be as such. We saw consistent conduct at KLA checkpoints that suggested to us a degree of regularity and consistency, which in our analysis meant orders and that were coming down.
You said they were consistent at the end but not at the beginning, is that right?
Over time, we saw an evolution manifested or reflected in a more systematic or consistent conduct.
Just a second. You're cutting him off again.
I think he's finished.
Were you finished?
In this case, I probably was.
Please do a short pause afterward.
But my question is, you noticed less consistency at one early point, and then you've made the point in your evidence and your statements at a later point it seemed to you more consistent and, if you like, organised.
Over time, we noted a higher degree of organisation.
Can we try to pinpoint those two poles of evolution? When would you say the period of disorganisation, because you've told us about KLA disorganisation and reorganisation by March in 1999, and when the period that you observed more organisation?
Sure. Well, my first research trip to Kosovo in '99 would have been June, if I'm not mistaken. June 98, excuse me, 98, yes. Apologies. And at that time, in our travels, there was a higher degree of disorganization, including some KLA members without uniform, and differences in different parts of the area. And then by September, we noticed a difference, that there was more uniformity, there was more consistency. That is when, for example, we were presented with military police in Drenica, I recall specifically. And by then, the orders for journalists were and for human rights investigators were being distributed, and we noted a higher degree.
So that's, I suppose, your degree consistent with what Mr. Thaçi was telling you in the meeting, that the organisation was trying to set up those institutions and make them operative. Is that right?
Oh, sorry, I'm pausing. I never disagreed and took as accurate, based on my observations, that the KLA was developing its structures and emerging from a disparate rebel group into a more organized military force.
But you think that happened by September 1998 at the back end of the Serbian summer offensive? I thought you told us it was March 1999 in your testimony.
No, this is, I think it would be artificial to identify specific points in time. This is a dynamic evolution.
But by the first, I mean, thank you on the military police or people manning checkpoints and so forth, but by the 1st of November, or indeed since then, did you find any evidence of corroboration that in November 1998, or in fact in September 1998, according to the press release, there existed a Justice Directorate of the KLA General Headquarters which operated a military court under the responsibility of a military prosecution? Did you find independent evidence to corroborate that claim, apart from the meeting with Mr. Thaçi and Mr. Limai?
So our information was based on what was told to us. We were refused permission to visit detainees. So we were not able to verify whether there was the detention facilities or where they were located or the existence or non-existence of a judicial
And you never found anything after that time to suggest that a Justice Department existed in November or September, November of 1998?
I'm sorry.
You never, at any time since then, came up with any corroboration that there was a Justice Department in existence in November 1998?
When you say came up with, you mean...
You never came across.
Do you mean in our primary investigations?
I mean, let's go back to where we started. You agreed with me that given the risk that the organisation or those issuing the statements might be intending to deliberately overplay the degree of their organisation in order, in part, to acquire support and present a more organised picture than they were, that they actually was the reality. And I think you agreed with me that because of the scepticism that you'd need to bring to bear in reading those documents, you'd be looking for independent corroboration of the truth of what they say before forming a conclusion. Is that right?
So the focus of our work and the purpose of our work is to document and expose violations as we gather the information. And the structure here, it continued to be our concern that the individuals, at least these two individuals, did not have a proper procedure and due process. That was the focus of our work. And the conclusion we came to was that they did not.
I'll come to that in a moment. That's not what I'm asking about, the two individuals, although I can follow that up in a moment. My question was, and it's I think, by implicitly not answering in a positive way, so to speak, you're probably answering in a negative way, but let me put it to you directly. Is it correct that you have no independent evidence, and found none, of the existence of a Justice Directorate or military courts and prosecutors in September, October, November 1998?
Not that I recall.
Thank you. So do you concede that this could be another of the examples of the KLA claiming the existence of structures that do not in fact exist, that it could be?
Could be?
Yeah, thank you. That'll do. For my purposes, that'll do. Let's move on. You mentioned the two individuals. And I think in answer to a question from the bench, you also said that you didn't know why their lawyer hadn't attended whatever proceedings these were. Is that right? You were told that a lawyer had been appointed, but you don't know why they didn't attend.
I believe what I said and what I recall from that time is that the information provided to us, this is the information provided to us, was that they were allowed to contact someone, and that person did not arrive, either did not want to come or was not permitted to come. But that's the information that was provided to us.
Now, as you know, when a lawyer doesn't turn up in any country in a police station to advise somebody before a court proceeding, they have the right to choose whether to wait and delay the proceeding or waive their right for a lawyer.
Correct.
Do these two men waive their right to a lawyer?
Just for accuracy, I think the reference, although not specifically cited, was to the appearance of a lawyer at a trial, not to a detention in a police
Detention,
station.
review, whatever, doesn't matter, to a proceeding. Now, as you know, an accused person is entitled to waive their right to have a lawyer attend a proceeding, correct?
They could waive their right.
Yeah.
They could represent themselves
They
if
could
they wanted,
represent
as
themselves.
Mr. Milosevic did in this
Exactly,
case.
and
I
cross-examined
testified.
you, I think.
He did indeed. Less effectively.
But let's assume that the lawyer was heading in his way when he got struck by a Serbian bomb. And it's put to them, you can either wait 3 days or a month before we find another lawyer, or you can go ahead and represent yourselves. And they say, we're not going to have a lawyer. We're going to waive our rights. Do you know if that happened here?
I do not know.
No, I'm only asking because about the depth of your... I'm not suggesting that is what happened. I'm just asking about how you went about investigating the illegality as you found it to be. Also, if they were Serbian... if the allegation is true that one of them was a Serbian national who was investigated and believed by the ICTY to have committed war crimes in Croatia, they might have been, would you agree, hostile to the KLA, if that were true.
Sorry, I think now we're getting into areas of speculation, and I object.
Sustained.
Very well. My question, though, is if you didn't know whether they'd waived their right to a lawyer or whether they'd boycotted the proceedings, how could you conclude that the process did not meet international standards? How could you reach that conclusion so definitively if you didn't know the underlying facts?
Well, our information, our conclusions were based on what the two individuals told us about, and we gave them opportunities to explain how the proceedings had advanced. They did not claim that the individuals had waived their rights to counsel. They also did not, excuse me, and they also did not argue that these individuals had been accused of crimes elsewhere. And so we reached our conclusions.
Yes, it's a very short point, really. I'm just asking, without a proper and thorough investigation of the underlying facts, how were you in a position to make a declaration of illegality and effectively tell them that they must therefore be immediately released, whatever they may have done? How did you get to that conclusion if you didn't have an opportunity to investigate the underlying facts? I understand the reasons for it, but how did you think it appropriate to reach a conclusion?
I object. That question, that's the same question was asked.
Okay.
Sustained.
Okay, that's fair enough. I accept that. Last question on this. If they had been spying, as was alleged in the Croatia allegation, you'd accept, presumably, it was lawful to detain them.
Yeah, I don't know about the allegation.
But if the
Croatia.
allegation is as it's been described, you would accept that it's lawful to detain them for imperative reasons of security under international humanitarian law.
If they had reasons to believe that they were conducting espionage, then yes.
Thank you. So there's no allegation they were mistreated. We don't know the underlying facts about the trial, and it would have been lawful to detain them if the facts that were put to you were correct. Thank you. Okay, let me move on to another topic. In answer to questions from Judge Barter, you described what you identified what you believe to be 6 categories of collaborator. Can you just remind us what the 6 categories are? Because it's obviously you who came up with them.
I'm going to object. There should be reference to the specific question.
Yes, well, I can give you
and
that.
response, because in fact the witness said he didn't know if he would identify 6 categories in particular.
That's correct.
Very well, that is correct. The reference is 7563. Judge Barker, thank you. And still in paragraph 82, you expressed your opinion in that case. Based on years of research in Kosovo, it is said that different categories of people, depending on the circumstances, were labelled by the KLA as collaborators, and I believe you distinguished between 6 categories. Whether it's 5 or 6, can you please just repeat them for us in summary form?
I can, yes. So again, the taxonomy of collaborators is a spectrum. It's a spectrum.
I mean,
so
this is your taxonomy.
Oh, yes.
It's not coming from anybody else.
no,
It's
it
a
is
taxonomy.
it is
Thank
my
you.
analysis.
Thank you.
It is my analysis.
Yes.
So I wouldn't put this into 6 neat boxes. It's not that
Yes.
straightforward.
Okay.
But to repeat myself, the top or the one end of the spectrum are individuals who worked for or were perceived to have worked for the Serbian security forces.
Yep.
Second, or again, down the spectrum, or along the spectrum, is those who worked for the state more
Yes.
broadly, not necessarily security services.
Counsel, if you just let him finish with that assisting with positive or negative responses, please.
I think you inadvertently are saying yes, you're agreeing with him. It makes, it interrupts the flow of his statement, and it also is difficult for the interpreter.
Very well.
Proceeding would be individuals who have condemned or criticized or actively spoken against the KLA.
Yes.
Then individuals who were perhaps not actively criticizing, but not supporting, not actively supporting. For example, not giving money, for example, to the Homeland Calling Fund, or otherwise being supportive by offering their homes to feed fighters, support the military campaign.
And are you suggesting that somebody who didn't provide their home was considered by the KLA to be a legitimate target for being arrested, detained, or executed? Is that what you're suggesting?
What I am suggesting is that a decision not to open your home would place a cloud of, over their home, because their loyalty to the cause is then considered potentially in doubt.
It's just that you've used the word collaborators, and that's a very important word in this case, because the prosecution are alleging a joint criminal enterprise which involves...
I don't think it's appropriate for counsel to explain the weight for his questions or the answers. His role is to seek information from the witness and allow the witness to answer.
May I respond, please?
Just go forward with questions that arose from the judge's questions.
Yes. Well,
we don't need to get into the joint criminal enterprise here.
Well, with the greatest respect, there couldn't be a question that more clearly arose from the judge's questions, because Judge Barter put this passage of the statement to him and asked him to endorse it.
I don't think he used the term JCE in his question.
That may well be right.
So we can ask it without, you can ask it without that.
Yes. It's just important that we understand what you mean by the KLA labelled as collaborators. Do you have an example you can give us of the KLA labelling someone who didn't give up their home for KLA fighters as a collaborator?
I can give an example
of that specific situation.
Well, the example that I will present, if it's helpful to the court, is list of individuals who did not give funds. This I am aware of, or I can tell you what I experienced, and it can be judged for its accuracy or credibility.
Mr. Emerson, please don't break in.
I'm just saying by all means. So come on, it's getting a bit silly with respect.
It is impossible to follow the transcript because your interruptions, inadvertent though I think they are, you constantly say yes, yes, of course, obviously. Just let him finish the question, then you can make your.
Okay, I won't argue the toss. The witness was asking me if that was an example we wanted to hear, and I was saying yes, go ahead. And if that's a legitimate reason for interrupting, then I accept it. Go ahead.
Yes. In June and July, when I conducted investigations, first in Kosovo, then afterwards in northern Albania, because tens of thousands of refugees were fleeing, of Kosovo Albanians were fleeing or being expelled from the western part of Kosovo. And so we went to Albania. And in Albania, in fact, in the town Bayram Suri, where the KLA had a presence, July 98, we're speaking, July 98. I met an individual who was a member of the KLA, or he presented himself as a member of the KLA. And he actually showed me a list. I did not read the list, but he had a list, and he said, you see, these are the people who are not supporting the cause, and we will remember them. Right. Now, I'm just stating what I experienced in that exchange. You know, it can be valued or devalued, but I did have that experience.
Okay, that's what this taxonomy. That's the one example you can give us.
That is an example I'm giving of a specific case related to people who didn't give financial support.
Thank you. I'll come back to that one in a minute. You also gave an example of a person whose family were deemed suspicious or disloyal because the father continued to work in the university when, yes, after the time that Albanians were no longer allowed to work. And I'm going to come and ask you about that as well. Any other examples?
So the taxonomy, if we can refer it, call it as such, is based on the body of our work.
Yeah.
So that means our investigations and our research, our communications and conversations with human rights activists, journalists, UNMIC investigators, K4 investigators, OSCE investigators, diplomats, and those who were tracking and following the conflict. And together, that is what has informed my analysis.
I understand, and we'll look at that in a sec. Of the two examples that you've cited, first of all, in relation to the university professor, nothing happened to him adverse, is that right?
As far as I know, no, nothing.
Okay. And in relation to the person who showed you the list, did he say...
Actually, I apologize. Now I interrupted you.
That's okay. Yes. I don't take objection quite so easily. Carry
on. But the answer to the professor is that I don't know. As far as I know, he was never beaten, detained, or worse. But the pressures upon him and his family are, and in those situations, the pressures can be unseen.
Of course they can be. They can be shunned by their fellow Albanians.
Or worse.
And we'll come back
or
to
pressured.
That. Yes.
Or pressured.
But you have no evidence of any of that.
In this case, no.
No. That's one example that you've been able to remember. And the other one is the man who showed you the list. First of all, since you didn't look at the list, you presumably have no reason to suggest anything adverse happened to any of the people on the list.
I cannot speak to that.
And did the person, you said the person concerned said, we won't forget the people who supported us and the people who didn't, correct?
That's correct.
And from that you deduced that they were identified as collaborators for not supporting?
No, I deduced that they were people who had been placed under cloud of suspicion or dislike.
But you've listed them as collaborators according to the KLA. I'm asking you, what it's in your taxonomy of collaborators.
No, what I gave you an example that was part of the full body of evidence that led to my analysis.
It's one of the examples of a taxonomy of collaborators, Mr. Abrahams.
Asked and answered
No, not
now
on.
repeatedly.
It's also argumentative, and it has been answered.
Well, let's just look at the background to this, if we can, for a moment. Because, can you give us the time period when the university professor felt that carrying on as a professor at the university made him, I don't know, unpopular?
The time frame is 1998.
1998. After the war or before the war began?
98, yes, 98.
After or before the war began?
That would have been after.
I noticed that you say in your witness statement, paragraph 81, that the whole question of collaborators and what they were is something that you first started focusing on in 1996, all right, I was checking the date correctly, in 1996 when you first worked in Kosovo.
Oh, that's correct, yes.
And you say some of your ethnic Albanian contacts would say occasionally that a person couldn't be trusted. And then you give the example of the university professor. And you said it was enough to besmirch the family. I just want to look at the context, because I'm going to suggest to you, you've shorn all of this evidence, all of this taxonomy of its context. Okay? You know the region well, so you're going to be able to answer the questions, about the context and chronology. First of all, you know, I think, that in July of 1990, the Serbian parliament approved a law which forbade Albanians from working in any government facility unless they pledged complete loyalty to the Serbian state and the Kosovo remaining part of Serbia.
Indeed, that is correct. A highly discriminatory law.
And almost all Albanians that were working in those circumstances lost their jobs, didn't they?
A great many.
A tiny minority remains.
I don't know the numbers, but in general...
a significant majority.
Agreed.
And for the next 10 years, unless they could find alternative work, these people had no income to feed their children with.
Their income was no doubt diminished. I'm not sure whether the parallel structures provided some salary. That is possible.
It's possible, but in terms of your knowledge of the situation, they were very significantly financially disadvantaged because they wouldn't pledge allegiance to the Serbian state. Is that right?
That is correct.
Right. This is around about the time when Serbia revoked Kosovo's autonomy. But then in 1992, they placed a restriction on transactions of Albanian property, didn't they?
I don't recall that. But
Albanians couldn't buy and sell property. You don't know that? Not something you're aware of in your studies? No?
I don't recall that detail. No.
Okay. Take it from me, and if I'm wrong, someone will correct me. Then the Serbian state started issuing weapons to the Serbian civilians in Kosovo and making it a serious criminal offence, punishable by immediate imprisonment for considerable lengths of time in some cases, for any Albanian to have a weapon. So does it come as a surprise to you, or is it in any sense remarkable that in that context, that the Albanian population generally were suspicious of the people who had pledged allegiance to the Serbian state? Is that a surprising situation in your view?
No, it is not.
Does it have anything to do with the KLA?
Yes. I mean, look...
Could you explain that for me? I'm asking what you causatively, you're suggesting that has something to do with the KLA. Who's responsible for that degree of bad feeling?
So, I mean, this is a complex matter that is related to the intersections of the politics, the society,
Correct.
and the movement to struggle against systematic and systemic persecution. And it's very hard to untangle those threads. So, you know, first and foremost, the blame is placed on Serbian and state structures.
For the hatred,
For-
is that right?
For the
Excuse me, you're interrupting again.
I just
Finish your question. Finish your answer.
Sorry, I just trying to understand what the responsibility for what you carry on. Start again.
For the discriminatory policies against the ethnic Albanian population at that time. And so the Albanians suffered under that, as is documented by us and others. Now, there is a popular view. There is also the view that the KLA or members or parts of the KLA, but including statements that were issued, that identified, labeled, and accused people of being traitors, of being disloyal, or of being collaborators, in ways that also, in my analysis, could be viewed as inciting violence or opening the door for violence.
But just to be clear, you were describing initially not the KLA, but attitudes generally amongst Albanians towards those who remained in the service of the state. Is that right?
The KLA was a movement, an armed movement, that also was a part of the Kosovo society.
Exactly.
And it's impossible to disentangle those two fully.
It may be impossible to disentangle them, but it would also be completely misleading to hold one subset of Albanians responsible for this bad feeling when it went right across Albanian society. Would you agree with that?
What I would agree with is there was a general feeling, emotion among Kosovo Albanians that labeled all Serbs as guilty or implicitly connected to violations and crimes. And a deep anger with the Kosovo Albanians who in some way were either participating in that, cooperating with that, or not adequately distancing themselves.
Last question on this topic, and then if I may, we'll take the break. Controversially, very recently, Human Rights Watch accused Israel of the crime of apartheid in relation to the occupied territories. Would you accept that the Serbian state was guilty of apartheid towards the Albanians?
Objection beyond the scope and speculation.
Sustained.
Thank you. We'll take it, if we may. Okay, fine. So, all right. I thought I had a little longer than that. By I reckon 12, I think.
I wrote it down. 10, 12 you started.
Very well. Very well.
I guess you get 8 minutes then.
Thank you. Okay, just move on to one other topic, if I may. You've levied quite a degree of criticism, particularly about Mr. Thaçi, but I think it's implicit as a criticism against the KLA leadership generally, that even after you went to see Mr. Thaçi to give him a copy of the Abuses Against Serbs and Roma reports, which was published on the 2nd of August 1999, he or they didn't respond to you to tell you what they were going to do about it, didn't respond to your recommendations, and didn't take any action effectively to investigate, suspend, arrest, or prosecute. Is that right?
That's my understanding.
Okay,
Yes.
let me just get the chronology right. You say in your statement that meeting happened in August. Can you give us a date for it, please?
It would have been 1 or maybe 2 days before the publication of that report.
So it wouldn't be in August then, because it was published on the 2nd of August. Are you saying the meeting with Mr. Thaçi happened in July?
No, it could have been the 1st of August.
Oh, I see. Okay, so was it the 1st of August?
I don't recall the precise date, but it would have been either the 1st of August or perhaps the 31st of July. But
pre-publication?
Yes.
Yeah, okay. And I want to just, can we just call up, please? Have we got a reference for the, oh, yeah, there we go. Resolution, Security Council Resolution 1244. It should be DKV 0461 to 0468, and it's a recent addition to our queue. Could we please look, first of all, at the date on the first page? That's on the underlined bit. As you can see, I mean, you're familiar with this, no doubt very familiar, is that right?
I'm familiar, yes.
Well, it was governing law when you were conducting your investigations, correct?
Correct.
And you can see it's dated the 10th of June. Could we turn over, please, 2 pages to paragraph 9 and 10? So this is the Security Council's decision effective from the 10th of June. So that's nearly 2 months before you met Mr. Thaçi and published that report, 2 months less 10 days. So the Security Council decides that KFOR will be immediately responsible for the international security presence to be deployed and acting in Kosovo. And if we look at its functions, first of all, KFOR had to ensure the withdrawal of and prevent the return into Kosovo of all military, police and paramilitary forces except as provided in point 6 of Annex 2. Broadly speaking, I think you know that the Serbian police, which was the law and order structure, had to be forced out of Kosovo by KFOR if they didn't leave voluntarily, and their return had to be prevented as of the 10th of June. Correct?
That is correct.
So there was no civilian police force at that time. Is that correct?
You mean Serbian civilian?
Civilian at all. There was no civilian police force at all. It was just a KFOR coming in and forcing out the Serbian police, correct?
That is correct.
There were no civilian police forces or establishments in operation in that period.
There were UN police forces.
Well, there were KFOR forces. The UN police forces under UNMIK didn't arrive at that point.
Sorry, what period are you?
The 10th of June.
The 10th
onwards.
of June. That is correct.
Okay. 9B, its function, second major function, was demilitarizing the Kosovo Liberation Army and other Kosovo Albanian groups. You see that?
Yes, I do.
So that means de-arming and demobilizing, correct? It was the function of the forces of KFOR to prevent the KLA from continuing to operate as an armed force with immediate effect. This is the law governing the time when you're criticizing the KLA for not suspending, investigating and prosecuting.
Criticizing the KLA and also KFOR.
Yes, well, that may be, but you're criticizing KFOR at a time when the Security Council has said only KFOR can do that job, but you're saying it was somehow shared with the Kosovo Liberation Army's responsibility, even though it was KFOR's job to disarm them and expel the police force, Serbian police force.
So the KLA's demobilization occurred on September 19th.
It finished on September the 19th.
Right, which means that there were still forces performing their functions up until that point.
No, does it mean that really?
Well, I am not familiar with the precise trajectory of the demilitarization, but the formal end, or the formal demilitarization or demobilization,
yes,
was on September 19th.
Let's be accurate. The end of the process of demilitarization was formalised on the 19th of September. It began on the 10th of June with the Security Council resolution and the entry into Kosovo of KFOR forces.
Correct.
So it becomes very important to know whether the KLA had the capacity to do what you were demanding of them, but as you can see, legally they didn't. Correct?
So we believed then, and I believe now, that there was an obligation on the part of this armed group, in the very least, to investigate what was taking place, with strong evidence of incidents and crimes, violations committed by members of the KLA, and committed in a way that we felt the onus was on the leadership of that time to take steps.
Yes, and that's exactly what I'm questioning with you. You have a legal regime requiring demobilisation over a period of June, July, and half of September. So that's 2.5 months. Halfway into that, well, in fact, 2/3 of the way into that approximately, you issue a report and you bring it to the attention of officials of the KLA, in this case Mr. Thaçi, demanding that they investigate compulsorily rather than progress with disarmament. Do you know, for example, before you criticise the steps that were or weren't taken, do you know whether in relation to any particular crime, you've mentioned 1 or 2 big ones that were committed at that time with multiple victims, do you know whether the authorities of the KLA military police in that area were still armed or had been disarmed and gone back to their villages? Do you know?
So first, we don't demand anything. Well, no, you
No,
said that
I can always add at the end of it, can you give me a yes or no answer, please? Do you
Well,
know?
regardless of if you ask for yes or no, if you make a statement of what I did, then I feel obliged to correct the matter. And we did not demand this of anyone. We do not demand. We present our information. We remind parties of their obligations, and we make recommendations. And what they do with those recommendations is on them.
Mr. Emerson, the time's up. If you have one comment, one short
Well, I
question.
wanted to look at the document. That's my final issue. But
Pardon me?
I wanted to look at a different document. If time's up, it's time's
Well,
up.
it's up.
Well, I mean,
Mr. Abrams, we're finished with your testimony. We would thank you for being with us, for sharing your information with us. You are excused now to go home, and we thank you for being here. The court usher will escort you out.
Thank you, Your Honors. Thank you.
We need a little extra time to get ready for the next witness. We're going to take a 40-minute break at the request of the people doing that. So we'll see you back at, what is that, 10 minutes till?
All rise. All rise.
Be seated. We are ready. Oops. Put this on. We are ready to begin hearing the testimony of prosecution witness W03827. Madam Court Officer, you can, I'm sorry, Mr. Court Officer, you can bring the witness into the screen.
Mr. President, I did want to raise one issue, if I may. We wanted to raise a point regarding disclosure with this witness. We do not know, of course, what the prosecution intends to use with the witness. However, we are not prepared to examine the witness to the extent either his health comes up or a recording of his ULEX testimony comes up. We have not been disclosed his health documents, so we are not prepared to effectively cross-examine if that becomes an issue, which I can't know. And secondly, if it's put to him, the audio recording, we have not had time to go through that audio recording, and we have not had time to have an Albanian speaker compare the Albanian answers he gives on the audio with how it was translated. So we are not able to cross-examine on those issues. I wanted to put
Any
that on
intention by the SBO to use that information?
Your Honor, we understood that there was a concern by the defense about any differences between the transcript, which was disclosed, and the audio, which we disclosed the first portion of last Friday. We had intended to disclose both portions last Friday, September 1st. Inadvertently, only the first portion was disclosed. The second portion, which is only 40 minutes long, was disclosed last Thursday. The 8th of September, or 7th of September, rather. So if Mr.
That wasn't my question.
I understand. I think the context is important because Mr. Misitich, inter partes, was actually the one that indicated a concern about a discrepancy that he highlighted. So if he's not concerned about any discrepancies, we're perfectly fine sticking with the transcript that was disclosed. But if there is any concern, the tape itself is a different version of the same evidence, and we do have it in the presentation queue available to be played.
So it sounds like at the present time there's no intention to use that audio.
Then that's fine, but I would put on the record that we did have a concern, which is just based on the brief ability we had to look through the shortened clip without having had an opportunity to have an Albanian speaker go through the entire, I believe it's close to 3 hours of audio. I can't tell you whether we have a concern about the rest of it, but if it's going to be put to him that, you know, is this accurate, either the transcript or the audio?
Sounds like they intend to use the transcript only until there's some question about it.
Okay, then all I would say is and frankly, Judge, in this 3-week period, we are in an all-hands-on-deck mode. So when we get a chance to breathe at the end of this session of witnesses, we will go back and try to compare the audio, and we'll reserve the right to recall the witness if necessary.
All right. We can come back to this later on if need be, but right now we want to get on with this witness. I will state for the record the witness for W03827 will be testifying via video conference, as is obvious to us in the courtroom, as granted by the panel in Decision F01776. Back into public session, please. Or are we in public session? Yes, we are. Good morning, witness. Can I confirm whether you have a copy of the solemn declaration?
Yes.
That to you, and I'll ask you at the end if you accept it. Do you understand?
Yes.
Solemn declaration. Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything which has come to my knowledge. Do you understand that solemn declaration?
I do.
To tell the truth.
I do.
Withhold anything that has come to your knowledge, is that correct?
That's correct.
So we're going to start your testimony today. The prosecution will ask you questions first. Counsel for victims will not be asking you questions today. Therefore, once the prosecution is done, the defense has the right to ask questions of you, and members of the panel might also ask questions of you. The prosecution estimate for your examination is more than 1.5 hours, and the defense estimates that it will need 6 to 7 hours. In regards to each estimate, we hope that the counsel will be judicious in their use of time. The panel may allow redirect examination if conditions are met. Witness, please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask the attorney to repeat the question or tell them that you don't understand and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. If you feel the need to take breaks, please make an indication and an accommodation will be made. So we are ready to begin. We will begin with questions from the SPO, the prosecutor, and then after that we will go through the other attorneys. Madam Prosecutor, you have the floor.
Thank you, Your Honor. Good afternoon, witness. I know that we've met before, but for the record, I'll reintroduce myself. My name is Deborah Mayer, and I'll be asking you questions today for the SPO. Consistent with the protective measures ordered for this witness, I request that we move into private session.
Madam Court Officer, please take us to private session.
Your Honors, we're in public session.
Thank you. We're adjourned till 2:30.
All rise. All rise.
Be seated. Before we bring the witness in, we will admit the prior statement of the witness under 143-2C. We will file a written decision so you have something on which to base further action if you need it within a short period of time. And we will, are you finished with this witness then?
Almost, Your Honor. I just have a few more questions, and then we'll offer the SPO statement as well. I think I've already verified it, but I just want to make sure that the record is clear that I take him to the beginning of the SPO statement, and on the same basis, we'll offer that as well.
So you're offering a second statement?
Yes, Your Honor. It's wherein he confirms the veracity of the earlier statement, where it's read back to him line by line, or page by page, I should say. And I did ask some questions before the break. I just want to make sure that the court is satisfied that I presented it to him completely.
And do you wish to attempt a cross-examination or to make a cross-examination?
Frankly, Judge, I don't see the point, unless the panel is going to find that we've somehow waived cross-examination.
No.
Yeah, well, then I don't see the point. I will just point out for the record that I think this is, however, precisely the difference between 143 and 155 is that 155 presumes the defense can't cross-examine, and 143 presumes that it can, but we can't.
Well, you never know.
Well, if he were to answer our questions, then that would undermine the very basis upon which his statement was admitted. And it would mean he committed perjury.
I'm just making it clear that you have the option to do that.
The option to do what?
To cross-examine if you wish to.
I don't want it suggested that we're waiving cross-examination. We're objecting to proceeding on this basis because we can't cross-examine him.
Understood.
Now, if you want me to go through the exercise, I'll go through the exercise.
No, that's your call. It's all your call. I'm just telling you what we're going to do and what your options are.
Well, may I consult then?
Sure.
Because now it's a confusing situation. Thank you. Judge, based on the panel's decision, I will proceed, and if he refuses to answer, I will be asking that you find him in contempt. Because the basis of your decision is that he's willingly not answering questions. I think that's contempt, and we will proceed to compel him to participate in cross-examination.
All right, call in the witness, please, Madam Usher.
Your Honor, as they're bringing in the witness, I do just want to clarify, this statement was admitted on direct examination where questions were posed to the witness, and the defense does have their opportunity. And the witness didn't just say, I don't recall. He actually did answer some questions, including denying having said some things, which
Yes,
is
he did. You're
different than an
absolutely
I don't
correct.
recall.
That was discussed.
Yes, but then there would be no cross-examination if you accept the answers that the witness gave, right? In other words, he didn't give any.
I don't think I can make it any more clear. When you're finished with your, whatever else you're going to do, offer all the exhibits at once that you wish to enter, and we will rule on them. Again.
I will, thank you, Your Honor.
Private session, please.
Your Honors, we're in open session.
Thank you very much. We are adjourned till tomorrow.
All rise.